So many Americans are simply tired hearing about so many Americans are simply tired of hearing about the former reality star turned 44th president of the United States. And now this same individual has been convicted on 34 felony counts in the state of New York. Our exhaustion and burnout regarding all things Trump cannot limit our wokeness as he's running again in November, and now as a convicted felon. Today, we're here to talk about all things legal and the Trump conviction with Charles Kelly Kilgore, an attorney and legal expert that will help us break down the current trial as well as all things criminal justice through the lens of Trump. Kelly, welcome. Thank you so much for joining me tonight. How are you?
Good, thank you.
Appreciate you bringing your expertise to the table. I want to talk a little bit about, because we kind of got to talk about legal ease for dummies. The average person doesn't know how the legal system works. And all of these Trump indictments and civil cases and criminal cases have kind of elevated to people the way the system works. So we know that for the first thing, the former president had a civil judgment with the E. Jean Carroll case of about $350 million. Can you talk a little bit about the difference between a civil case and a criminal case, and how that case with the E. Jean Carroll case differs from the criminal cases we recently had, not just indictments, but we had convictions on in New York State?
The easiest way to think about the difference between a criminal case and a civil case is to look at the title. If the government is listed first, then in all likelihood, it's a criminal case. So it may say the United States of America versus Donald Trump, or it may say the people of the state of California versus Kelly Kilgore, or it may say the Commonwealth of Kentucky versus Rachel Hansen. And that all clues you into the fact that criminal charges are being leveled against those three different people. Now, that doesn't mean that there can't be a civil case that has the government come first if they're seeking money or forfeiture, but that really is the best way to look at it. Or to look at a civil case, it's generally somebody suing somebody or trying to agree to what they consider a wrong. So that may say Sam Jones versus Adam Smith. You know, right away, there is no criminal case involved, because there's not a governmental entity involved. It's going to be a civil case. The biggest difference as far as the legalities go between a criminal case and a civil case is that in a civil case, all you have to do is prove your theory by what's called a preponderance of the evidence, which means it's more likely than not it happened the way that you are describing it. And we often talk about a set of scales. People can envision scales, the legal justice scales in their mind. And if you put a P or a penny on one side of the scales and it barely drops that scale, that's enough for that party in the civil suit to win. Okay? It's a very, very low standard. So people don't have to be convinced. They just have to have an inkling or an idea or a preponderance that Mr. Jones is correct and Mr. Smith is incorrect. In a criminal case, it's the highest standard that we know in American law. It's beyond a reasonable doubt. Oftentimes people say the reasonable doubt standard, and I think that's even incorrect because it's beyond a reasonable doubt. People have often equated that to 90% or 95% or even 98 or 99%. Just as an aside, we often get to define what we think reasonable doubt is. And it is true that it's not beyond all possible doubt or the shadow of a doubt, that it's extremely close. So what I've just suggested to you, the makeup of the case, the title of the case, and the different and the burdens of proof are what distinguish civil cases from criminal cases.
That's really, really helpful. And I know enough to be a dime store lawyer because I sat on a grand jury in Kentucky for a month, which was
Huh?
which was very interesting in Fayette County. But the other piece that I think is interesting for our listeners is that a civil case usually involves some type of what we normally know as a monetary, right? Or some type of whole making to a person. But in a criminal case, that's where jail, prison time, remediation in that case, whether it's probation or community service or whatever. As we pivot, because former President Trump has had civil cases and then has federal criminal cases that are right now in Florida that the federal government has brought. The most recent is the conviction on the 34 counts in the state of New York. Can you talk a little bit, because we hear the word indictment and we hear the word conviction and then we hear the word charges. So in the case of the state of New York versus former President Trump, the state brings the charges and then you have an indictment. Talk about how those different layers work, from charges being brought and then an indictment taking place, and then what happens if there's a conviction or not.
Okay. First of all, the Attorney General is a prosecutor that can bring the charges, but so can the district attorneys. And it was the district attorney in New York, in Manhattan, that brought these charges. Now, interestingly, he had looked at them previously and sort of punted on them, but then resurrected them. And that can be for a variety of reasons. That is not necessarily nefarious or evidence of any wrongdoing. Oftentimes, more evidence is added to the case until you think, okay, now I think I can prove this beyond a reasonable doubt. What happens, the way that a criminal case unfolds, is there's an investigating agency, or it can be special investigators within the prosecutor's office that investigate the charges. Then they take that to a filing prosecutor, often a filing deputy district attorney. And then you mentioned indictment. In the United States, criminal cases can proceed in one of two ways to get it to a trial. One is by way of a preliminary hearing, and the other is by way of indictment. And both of those are designed to show that more probable than not, or a preponderance, like we talked about a few minutes ago, a preponderance has been shown. And what that is that there has been a crime committed and that it's likely that this is the person that committed it. It's a very low standard. In the 30 years that I've been doing this, I've probably only seen twice that a case was not what's called held to answer or bound over to the next court. That's when you start getting a jury together and you rise to that level of beyond a reasonable doubt. What happens at the preliminary hearing or the indictment, in the indictment, the prosecutor goes in front of a grand jury. Now, I have never seen a grand jury. Guess what? I never will see a grand jury because the defense is not allowed. I've not been a prosecutor. I've only ever been a defense attorney. So that's secret. And that's also not nefarious or any evidence of shadiness or anything like that. In the beginning, the founding fathers thought that this was a way to protect people, that they could go, the prosecutor could go in front. If there was enough evidence for this person to be indicted, well, then, hey, we tried to protect your identity. We tried to keep it a secret to find out if there was enough, but they didn't want rumors running rampant. Right?
Well, in Kelly, to interrupt, in the case of when I was on a grand jury, the reality that I want to lay out for folks is the grand jury, just like a regular jury, is just comprised of regular citizens.
That's right.
It's just people. So it isn't a district attorney or an attorney general. They are bringing the charges, but stuff doesn't even go to trial unless it has an indictment by regular folks.
That's
right?
exactly
Kelly,
correct.
Okay.
Yep. And you start to think about the numbers, because oftentimes there are more grand jurors than there are regular jurors, which is routinely 12. Now, if you can convince this hodgepodge of grand jurors that this is the person that may very well have committed the crime and in all likelihood has, and that there is criminality involved, and it's what has saddened me in watching all of the coverage is just the distrust of the American judicial system that people have. I keep my political opinions private to myself. I only opine about things that are legal. And I am really highly annoyed and offended that people are trashing my profession when it's been fought over, people whose aunts, uncles, grandparents died to preserve these causes are now, and really, legally speaking, not politically speaking, I think that Donald Trump is at the forefront of this. There is no way in my mind that Joe Biden could have had a hand in any of this. One, it's not brought by the federal government. It's brought by the state of New York. And quite frankly, I think the downside is just too steep. What if Joe Biden did reach in there and put his finger on the scale and said, go ahead and bring these charges? That would be the end. And it's just not, I've been doing this for 30 years. It's eminently fair. I trust the judicial system. I trust the jury system. And I trust most of the time for people to play ethically. And that's one of the things that is something in our profession. We call civil law. It's rarely civil. It's rarely polite. It's often no holds barred, and they're just fighting over money. Whereas on my side, people bend over backwards to make sure that justice is preserved. And I can't think of a time that I distrusted a prosecutor. And that's all I want. A prosecutor's not going to stop or stumble and say, oh, Kelly Kilgore is involved. I like that guy. I'm going to do him a favor. That's not the way it works. As long as they're open and honest and fair, then I think that that's exactly the way that it should be. And I think that's the way that it has been. Now,
Yeah.
If you want to argue about whether charges should be brought or whether it's low level, that's a whole different discussion.
Mm-hmm.
But
and you're laying out really well for us that, okay, so the charges are brought, we get to a burden of proof that a grand jury has to have to decide they're going to indict on, in this case, it was 34 counts, right? So they could have taken counts away. They could have added counts. They could have said, no, we're not going to do it at all. They decide to move forward to an actual criminal trial.
Correct.
Can you talk a little bit, because you work in the defense area and the prosecute area, talk a little bit in the cases, because this whole Trump thing is just a great civics lesson. The whole experience of Trump has been a hell of a civics lesson,
Yes.
right? But to get us to realize, so how are jurors selected? Because in the state of New York, people are called for jury duty, and the prosecutor as well as the defense has a right to dismiss jurors. And it isn't like the state is saying, these are the people you have to have. So talk about how in this case, but in any case, even if the federal government was politically motivated to lean on New York to bring the charges, you would have to get through a grand jury and have to get through the actual trial jury, in which the defense had as much to say about who was on that jury as the prosecution. Is that fair?
Yes. So before I start in with the jury, let me step back and tell you the comments that former President Trump has been making about the change of venue. And the change of venue was he wanted that move to a different locality, a different community, to get a different set of jurors, right? Well, the standard for granting a change of venue is that a fair trial cannot be had, usually because of pretrial publicity. My argument is there is nowhere in the United States that didn't know everything there was to know. So a change of venue from Manhattan to Bronx, Queens, the Hamptons, Saratoga, upstate New York, Ithaca, makes no difference whatsoever. So to me, that change of venue, that's just a complaint or a whine that the former president is having. So what happens with a trial, and I'm getting ready to start a murder trial in Los Angeles, and we're going to end up with 12 jurors and probably 4 alternates, but we'll probably go through maybe 70 or 80 jurors. And we're looking for what's called for cause. Okay. Now, in my legal framework, in my legal view, if you want a jury of your peers, I think you bring the first 12 people in and sit them down, and those are your jurors. Now, that may be advantageous for the prosecution. It may be advantageous for the defense or disadvantageous to either side. For example, if I'm representing somebody in a rape charge and juror number 7 was the victim of a rape, bad news for me. So I get it, right? Now, but on the other hand, jurors are supposed to draw on their breadth and their life experiences and what it is that they've come across in the past. So there's, that juxtaposition there. So there's a lot that goes into the jury selection. It's vitally important. I think probably the highest paid people in the world whose jobs I don't understand are jury consultants, because I often like to stay after a trial's finished, whether I've won or I've lost, and speak to the collective jurors there. And they will tell you things you have no idea about. And you're like, well, at first she said the car was green, and then she said the car was light green. And you're like, okay, I get it if she said the car was green and later they said the car was red. Maybe that's a misidentification, right? But sometimes it's these things. So with regard to jury consultants, maybe they have a place. Maybe I would use them if given the opportunity. But the jury selection is a huge, huge part. I am very vehement about letting people off the jury. I'm not against it. I get these lawyers and these doctors, and they come forward and they're like, well, I'm a doctor and I'm very, very busy. And the judge will say, approach. And we go up and I'm like, Your Honor, I don't care if he's the president of the United States. Everyone should serve on jury duty.
So, Kelly, tell us about then as it relates to the New York trial. So we were talking about how juries are selected, jury consultants, all of these different folks. Talk about, because on those 34 counts, the 34 felony convictions, it only took the jury, I think it was 9 hours to convict. And you're talking about beyond a reasonable doubt, 12 jury members, citizens that are supposed to be the peers that both the prosecution and defense together agreed upon. Can you talk about what those deliberations potentially looked like? And did you think going into this one case that it would be such a quick jury response or the jury coming back?
Not in a million years. The charges were so convoluted and complicated, okay? They were originally misdemeanors unless they were committed to cover up another crime, which raised them to a felony. So then the jury would have to look at it and say, okay, were the misdemeanors committed? And were they committed to cover up another crime? And if so, what was that other crime? This is pretty heady stuff, okay? And I would have thought they wouldn't necessarily have taken, let's say, 30 minutes for each of the 34 counts, which would have given you what, like 17 hours of deliberations? Okay, but something close to it. I always find that jurors take their jobs very, very, very seriously. Now, one of the theories, and I subscribe to part of this, first, I don't think this was a hush money trial. And second, I don't think it was a campaign finance trial. It was a falsifying business records trial. But you probably know from what you do as a podcaster, that's just really not terribly sexy, okay? Hush money is way better. Porn star is way better, okay? And evidence of campaign tampering is way sexier, all right? What I think ended up happening was they probably gave short shrift to Michael Cohen. They gave short shrift to Mr. Pecker, and they concentrated on the documents. Now, I saw one of the talking heads, and I'm not sure I'm ready to go this far, but one of the talking heads said they would go so far as to say the prosecution centered themselves on Michael Cohen so that the defense would center themselves on Michael Cohen. And in the meantime, they would come forward with all these documents, right? So if that's true, then I can understand how that verdict was reached that way. I was very surprised. I was even more surprised each time the jury had a question, because I'm thinking, okay, that's 30 minutes, 35 minutes for the judge to read them. Then another 15 minutes for the foreperson to be reassured by all the jurors that they understood what the judge was saying, and then to take that conversation, that discussion off in that direction. I never in a million years would have I thought the jury would have come back that quickly and unanimous on all of the charges.
Right. The piece of this that I want to make sure to underscore, because whatever politicos and the 73 million MAGA voters who believe what they believe, and they have a right to do that, but these are everyday citizens. And
Yes.
I've done jury duty, sat on grand juries. There wasn't a time that everybody there did not take that work seriously. And that was just a regular grand jury, right?
Yeah.
We educated ourselves. The judge was, when we ran at the end of the day, had to read. The judge had to go through the indictments, and we had to do all
Right.
the things. And the judge just remarked on how seriously we had, and that citizens take this work, and citizens are becoming even more educated to realize, if I put an indictment against somebody poor or somebody who has mental illness, odds are they're probably going to have some level of conviction down the road. So
Yeah.
people were taking that work very seriously. I can't imagine being a juror in the trial of a former president. Right. So to discredit those people and say they were politically motivated or whatever, everything I've heard from people in that courtroom was how people remarked how seriously, how attentive, how on point these folks were, because this is truly historic, right?
Right.
Kelly, tell us. Go ahead.
I was going to say, I would even argue with you. I'm not with you. I would even argue to the general populace that all juries take this seriously.
Yes.
It's not like they sit in there and they're like, oh my gosh, I've really got to do a good job. It's the former president of the United States. No. It's more like, this is the United States of America. No. I get two opportunities to serve my country. I can join the armed forces, or three. I can vote, or I can serve on a jury. So I think, now what I was going to say, this whole idea about Trump being unpopular and people not liking him in New York, I would not think that that would matter at all to a juror, except to the lengths that he went in the courtroom of disrespecting the judge. That is not a good idea. Any juror is going to sit there and say, you may be the former president of the United States, but you're in a court of law, and you will adhere to the decorum and the respect that the judge deserves. And he didn't do that. Now, I don't think that's responsible for the convictions, but it certainly didn't help.
It didn't help him. Yeah. And I want to underscore that what you are saying is spot on. I have never, my sitting on a jury, whether it's a homeless person in downtown Lexington being having charges brought for vagrancy, or it's a murder, because we had several of those as well. Right. Folks took it just as seriously. Yes. And took it just as seriously to protect the citizen, whether it's the victims, the people, or the so-called or the potential, the accused, right?
Right.
Kelly, talk about, so we have 34 convictions in this case, and this is unprecedented because in all but one state in the country, a felon can't vote. So how are we? Yeah. How is this going to work, that a major political party is going to have, presumptively, as their nominee for president, somebody who can't vote in all but two states in the country? How does that change kind of our legal system and our political system? And what about if it went the other way? Are your thoughts that that would have some political ramifications? I know you don't want to be too political, but it's something that I've thought about, because it's interesting to me that you've taken people's ability to vote away if they're a felon, And it doesn't matter if their conviction is over, they serve their time, they're off probation and parole, they've done all their things. In most states, almost every one of them, if you've been convicted, you can't vote. And in the case of this person who is going to run for president, they're not going to be able to vote, but they're going to get a lot of votes.
Right. Well, first off, I disagree with taking away the right to vote. If you really want to alienate somebody, you start doing things like that. Here's where I think that a judge, a prosecutor, and I can all agree. And I often argue this in court, and I'll argue it in my moving papers and my motions, is we all should be looking at it and thinking, what can we do to make sure that we do not see this person here again? In other words, how can we make it, how can we rehabilitate this person? Or how can we make it so that this person doesn't commit any more crimes?
I've been trying to explain this to my mom, right? So now on July 11th, we have sentencing.
Yes.
So the judge is the one who sentences, right? And you have sentencing motions and all of these things. And then the judge decides what the sentence will be.
Right.
What are the judge's options on these 34 counts? And what, in your legal opinion, what do you think is the most probable outcome regarding sentencing?
Okay. His options are prison or no prison with probation, or probation with a fine to be levied against him, or possibly even not prison, but home incarceration. I don't think that he will receive any prison time, and I don't think he deserves any, because at my core, I'm still a defense attorney, and we're looking at a person with no prior record. It's nonviolent offense. They started out as misdemeanors. Even when they were elevated, they're still low-level felonies. And I think that this judge is going to bend over backwards to appear fair, so that Trump can't come out and say, well, that judge hated me, or that judge was corrupt, or the Republicans could do that. And I don't think he wants to add any fuel to the fire. Okay. There is this whole argument that he hasn't shown any remorse, but I don't think that that trumps the fact that they're low-level felonies, there was no violence, and he has no record. And in cases like this, somebody generally gets probation.
Well, now, Andy's 77 years old, which has something to do with it as well. I think I agree with you. I think the judge has shown more respect for the office of the president and former president than the 44th president of the United States. I think the judge understands the gravitas of that.
Yes.
Whether it's about the person, he's thinking about the position and the impact that has on a nation. Good point.
That's absolutely true. And then there's the really very real practicalities. How do you house the 6 or 8 Secret Service agents that are assigned to the president if you put this guy in prison? I, frankly, don't like to think about the specter of one of my presidents, no matter who it is, one of my presidents being incarcerated. It already bothers me bad enough that we've got one that's been convicted of felonies. I mean, why do you think the man gets to run for president? Because the framers of the Constitution, the founding fathers, they never envisioned this. Otherwise, and it certainly seems like they envision everything else. So I think that he'll get probation. I think he'll probably receive a fine, but I think that the judge is going to bend over backwards to appear fair and be fair.
And there's a lot of talk, because especially in communities of color, right? Well, if that was us, they would have put us under the jail. 100%. If a bunch of brown people tried to insurrect the country and override it on January 6th, it would have been a whole different outcome. There's a lot of people that feel that and believe that.
Right.
We thought, to your point about the framers of the Constitution, I mean, we thought people thought the stuff Nixon did was dirty. I mean, or the stuff that Bill Clinton got impeached for. This guy has, I mean, this is the first conviction, but in a criminal case, but we're talking about multiple civil judgments, multiple civil losses, all of these things, right? Where he's kind of used the epitome of using his privilege to get out of stuff. And I mean, I still remember when former President Obama was criticized for saying a police officer acted stupidly for arresting Henry Louis Gates in his own home, right?
Right.
Or that he wore a tan suit and how outrageous that was, right?
Yeah.
It's crazy to think how far we've come, no matter what your political leanings are, and that our appetite has just become desensitized to this reality star universe, right? So
Yeah.
if Trump wins, right, in November,
Right.
and he becomes the president again in January, what are the chances? Because I know that the Supreme Court is right now hearing arguments around potential presidential immunity for these kind of things. What are the chances if he wins, he just does a broad brush immunity, or Supreme Court just does it, and he can then just be kind of a president in a democracy just in words, but kind of say, I'm all-time president, like I was all-time quarterback when we play quarterback, when we play football on the playground in elementary school.
All right. So that's a lot to unpack. One, I would say this. If people were educated about the New York State trial, you haven't seen anything until you've seen these federal charges come together. There is going to be no way that he can wiggle out from under this stuff. The feds do not bring charges unless they're going to win. That rarely goes to trial. And a federal judge will not put up with any shenanigans whatsoever. If Trump pulls the same stuff, if he's in federal trial and federal court, if he pulls that same stuff that he did in New York, he will get canned. Maybe just for the day, maybe just in the holding cell, but a federal judge will not put up with it. And let me take a moment and talk about federal judges. One quip, and then seriously. And the quip is, the difference between a federal judge and Jesus is that Jesus doesn't think he's a federal judge. But
I love it.
So that federal judges are maybe the most brilliant thing that the founding fathers did. They insulated them from public and political scrutiny by not having them run for elections. This is directly, not indirectly, this is directly responsible for the civil rights gains in the South in the 50s and the 60s. Because you had these crackers who all talked like each other and looked like each other, but when push came to shove, these federal judges did the right thing and made the right calls because they were impervious to any political pressure. And what happened in the beginning was the founding fathers, they foresaw not only that, but they also foresaw a Virginian coming to New York to do business and then being taken advantage of, or vice versa. Somebody from Vermont traveling down to the Carolinas and getting into a scrape and not having a voice or any protection. So all of this was built into this federalism. So the point is, these federal judges are appointed for life. They cannot be fired. They cannot be questioned. They can be impeached, but that's so rare as to have never happened that I'm aware of. And so it's going to be a different kettle of fish. Now, do I think that he probably won't get any time? And I'm going to say when he's convicted, not if he's convicted. If he listens to his lawyers, and there's no guarantee of that, then he will probably try to plead to some kind of deal and say, basically say, look, my life's already been screwed up. I'm already labeled a convicted felon. I don't want to serve any prison time. So I'm willing to take this, especially if he's already won re-election. Then he's probably thinking, well, gee whiz, I'm the president. I don't care if I've got these other stains on my record at all, but I'm not going to take a chance of sitting through a trial and then a federal judge throwing me in the clink.
Kelly, that's crazy. So you're talking about for everybody who's lost, right?
Right,
So what Kelly's talking about is we have the civil cases, we have the criminal cases brought by states, right? So we
right,
have the one in New York, we have the one in Georgia, right? The
yeah,
Fonnie
right,
Fonnie Lewis, right? Fonnie Willis
yep,
in Georgia, and then we have the one in New York that he was just convicted of. Then we have the two federal, I think it's two, right? We have
right.
the documents case, which is sitting with a judge who's delayed it indefinitely in Florida. And then we have another federal case related to January 6th. Is that correct? Are those the two
Yes,
federal cases?
right. That's where we are. So, and let me say it this way. I'm going to say three cases. There's the New York case, the Georgia case, and the federal case. Out of all of those cases, the New York case was the weakest, and he just got slammed with 34 convictions. If that's the weakest, and all the legal pundits seem to agree, me included, then he's really in trouble. The Georgia case is a better case, and the federal case, the feds just don't bring charges unless they're going to win a conviction.
Right, right. And so he could, in this potential world, he could run for office, win, right? And the
Right,
federal case still be sitting out there, even though you're the president and you think you can fire the Justice Department. Is
right.
that
But
correct?
instead of doing that, I think he would just pardon himself.
Right. Yeah.
Now, he cannot do that in New York. And people don't, this is where it drives me crazy when people get things wrong, right? They're like, well, he's going to appeal this all the way to the Supreme Court. No, he's not. No, he's not. There's no federal question involved. Okay. Unless for some reason they're able to point to some kind of unfair trial, which I don't see that. He would stop at the New York Court of Appeals. And let me say that to educate our listeners, things are different in New York. In New York, you start trial in the New York Supreme Court. The Supreme Court is not the top law of the land in New York, it's the bottom. And then you go to several appeals courts up to the New York State Court of Appeals. And that's where anything with regard to this trial would stop. But let me tell you this, okay? Appeal is going to happen. They absolutely are going to appeal, and they have very, very good grounds for an appeal. That's usually not the case. Okay. One, this is a case of first impression. We've never been here before. Mistakes can be made. How serious were the mistakes? Were they serious enough to affect the outcome of the trial? My argument is any mistake is a mistake that can affect the outcome of a trial. But here we've got I told you it was convoluted and very, very complicated,
Sure.
elevating from the misdemeanors to felonies. It turns out, and I just learned this, that the New York District Attorney's Office hired a law firm to research this question. And now all of a sudden, let's say you put that in a brief. Gee whiz, all you honors on the Court of Appeal. If the district attorney didn't even know it was a crime and they had to hire a bunch of lawyers to tell them so, how could the jurors know? How could the public know? How could Mr. Trump know that he was doing anything wrong if nobody even knew what the law was? So that's a pretty good grounds for appeal. Then there is the specter of Stormy Daniels. I have no idea why she was a witness in this case. She had nothing to do with the records whatsoever. If I was the defense, I would have looked at her when it was my turn to question her under cross-examination, and I would have said, "Hi, Ms. Daniels, how are you today? Do you work for the state of New York? No. Did you work in the Trump organization? Did you ever work for any of Trump's businesses? Do you know anything about his record keeping? No. Thank you. Your witness." Right? But they went so far afield of this, in an attempt to muddy up Trump with the salaciousness when it really didn't have any core connection to the trial. So that's an appealable issue. Was I prejudiced by the introduction of some porn star? So he's got a shot. He's got a shot on appeal.
Well, and I think, Kelly, the bigger question that you're talking about is, you and I are not spring chickens, is what my grandma would say.
Right.
I just never thought we'd be here. I mean, and the part that to me is just so disheartening, whether I agreed with Bush 1 or Bush 2 or Reagan, or, I love me some Barack, so I'll just be honest, right? So,
right.
But any of them, they're still the president. They're still, okay, we're still respecting the office. We're still all the things. And it isn't the person, it's the people that, in spite of this, I told a colleague of mine who continues to, believe these things. And he said, I said, by the time when the conviction happened, I said, I guarantee you by 8 o'clock tomorrow morning, I'll have multiple texts and email from Donald Trump to raise money. And I had 15 emails and texts, right, to raise money.
Right.
The really scary part of this is that this will only embolden the people that support him for president. And I guess because part of the reason a person becomes a defense attorney is because folks I know, the defense attorneys I know, believe that no matter who you are, you deserve a fair trial. That is a right as an American, whether you're Trump or you're a murdering drug dealer from the neighborhood, right? No matter who you are, you deserve these opportunities. And in this case, it just seems like the scales have fallen from all of our eyes, and we're realizing that the justice system isn't completely blind. And all that matters is your willingness to take advantage of things. And if you have the power and the money, you can essentially do whatever you want. And so what I'm hoping you can finish us off with is some legal foundation for how we can all still believe that justice is truly blind, and you can't, depending on your office, just do whatever you want. How is there ever going to be some level of accountability? Because this is not about this president, former president, or this point in time. It's about the precedent that we're setting for our children, our grandchildren, and our great-grandchildren.
Yeah, it frankly scares me. It scares me very badly. I never thought that the rule of law or our system of justice would be held up to ridicule. Now, having said that, I do think that former President Trump has been brought up short. I do think that the criminal justice system was honored, certainly by reason of those 34 convictions. I mean, those 12 people didn't seem to care that he was the former president. I think they went in there with a job to do, and they did it. I hope that can be reverberated, perhaps by teachers, teaching children in elementary school, civics lessons, somewhere along the way. I always think, I was in my first year of law school when Rodney King happened. And I remember coming into school that day, and everybody was all abuzz, right? And so I stopped some people, and I was like, well, I didn't see that. And they said, well, believe me, you will, right? Now, here's what I take from the Rodney King case. Think of the millions and millions and millions of dollars and all of the resources that we committed to help what otherwise would have been viewed as a poor thug, right? That in any other time and place in history, or perhaps any other community or any other country, would not have gotten the time of day, would have just been written off. And what we did to preserve all of those rights, I mean, still just astounds me. And that's one of the beauties that I think that I see, in what I do. And it's interesting because I always get the question, how can you do that? How can you represent those guilty people? And I usually say, because Jesus Christ is my Lord. And in Matthew, he says, whatever you do for the least of mine, you do for me. Well, let me tell you what, that backs people up really quickly and effectively. Okay. So, but to answer your question, what are we going to do? Like I said, it frightens me. There are people out there that believe that Biden has his hand on the scale. They believe that he pulled off this election interference, stole the election. And I tease all my Facebook friends. I go, really? I can't believe you guys are willing to admit that the Democrats are that much smarter than you guys. How come they're pulling this off and you're not? And if they're pulling it off, why didn't you catch them? And, they never seem to get that. And I say it tongue in cheek, but really it disturbs me down deeply.
Kelly, I thank you for your expertise, for your time. We're going to have you back, because I don't think this is going to be the last time, my brother, that we're going to talk about crazy legal stuff. And to be frank, the thuggery that some of these folks commit, and the people's willingness to just be blind and hold it up makes me nervous as well. But I have a lot of faith in us, and I have a lot of faith in the people, if we're willing to stay in these uncomfortable spaces and have these kind of conversations today. So thank you so much for your time. I appreciate it.
Thank you very much. I appreciate it as well.
We appreciate you joining us for this episode of Get Uncomfortable. There are a variety of ways that you can support the show, including leaving a review, sharing an episode with a friend, or visiting us at getuncomfortablepodcast.com to visit our merch store or request sponsorship information. Until next time, stay uncomfortable.